start without her?
Yeah, it is 5:30.
Okay, well, welcome to this Plan Commission on January 11th, 2024 for the City of Santa Clara. We'll call the meeting to order and we'll start with the opening ceremony. The Pledge of Allegiance and invocation will be led by Commissioner Whitehead.
Please arise and join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our dear Heavenly Father, we bow our heads before Thee this evening to give Thee thanks for the blessings that we have. We're indeed grateful for the City of Santa Clara, this community in which we live, and the friends and peace and freedom that we experience here. We're grateful for this country and ask a blessing on those that are at the helm of it, that they'll be able to manage and lead in the way that affects us all in the direction that we need to go. Please help us this evening that as we talk about items on the agenda that we'll be able to be productive, stay on point, and do what's best for the City of Santa Clara. Again, we're grateful for this community and we ask a blessing on those within the city boundaries, that they'll continue to thrive and have those things that they need to be successful and enjoy living in this community. We love Thee, Father, and say these things in the name of Jesus Christ. Amen.
Amen.
Amen. Thank you, Commissioner Whitehead. Looking at the agenda, looks like our first thing we should do is probably introduce our newest commission member, Cade Roberts. Do you want to introduce yourself?
Sure, yeah. I'm Cade Roberts. I've been in Santa Clara. I grew up in Ivins. I grew up there since I was 12. I have a lot of family still over there, actually. A lot of the Yance family lives there at my mom's side. And moved back after school, and have lived in Santa Clara ever since. So I live over by Curtis in the same neighborhood, and we love it. I don't think our kids will ever let us move, so we'll be here forever. We have 4 children.
Awesome. And then you mentioned your profession was an engineer, you said?
Yeah.
Right?
Yeah. We've seen each other a couple times. I have a firm right behind the mall in those suites. We have a small firm. We do mostly Utah Department of Transportation work. In fact, that's probably 80% of our contracts.
Oh, are you just down that street behind Red Cliffs?
Yes.
Mall?
So that's
Okay.
Mall.
Are you on Mall Drive?
Mall Drive. Yeah.
Oh, okay. Yeah, I think I've seen your sign.
Yeah.
I'm in that area, so. Thanks, Cade. And
Great.
Cade was appointed by the City Council on December 13th. And tonight is his first meeting because Ryan Anderson served his last meeting on the 14th of December. And Connie was also appointed that night, but she started on the 14th the next day. Very similar to when Kristen started. She came to a council meeting and then was here the next day. So.
Great. Well, good to have you. So I guess we move on to the. Are we doing the training first, or are we doing the election?
I thought we'd do the training first. Is that all right, Chair?
Yeah. So item 4A, a Plan Commission training. Turn the time over to Mr. McNulty for that.
Thanks, Chair. Just wanted to spend some time this evening on some training, maybe 45 or 50 minutes, just some basic training, Planning 101, Commissioner training, just kind of, an update, refresher. There are some training opportunities. There will be a training opportunity in March. Commissioner Logan Blake just mentioned that to me, that the training that some of you attended last year through the Utah Land Use Institute, and that was done last year in April here in St. George, is going to be on March 22nd. In St. George, I believe at the Abbey Inn. It's a day-long training. It's $150 per person, but it's worth every penny, and it's time well spent. Many of us attended last year. Some attended. It was broken into 2 days last year, so it was a half day Thursday and then kind of a 3/4 day or 2/3, not quite a full day, but most of the day on a Friday. This year, they're just doing one day, was it 8:30 to 4 or something
Yeah,
like that?
yeah, it was on March 22nd, 8:30 to 4 p.m., Abbey Inn on Bluff Street. And you can just go to the Utah Land Use Institute website and find the link to register for that event.
And we will register you for that. I will send an email out to everybody next week saying, please let me know if this date works for you, or you can tell me tonight. And then I will get you registered and we'll pay the fees. We just would like you each to be there. That provides the 3 additional hours of training, even though it's more time than that. That provides the additional training as per state code. The training I'm doing is just the basic training that most of the cities are doing now, and letting the league and the Land Institute with their professionals. And many of the people that come teach that have a legal background or a land use program background. One individual's been a land use planner for almost 40 years, and now he's on the teaching circuit, and he does very well. His name is Wilf Summercorn, and he'll be there leading a lot of the discussions. So he talks about how he started in the 70s. And wow, when you think about that. So it's a long time to be in one field, but there'll be a lot of good professionals there that day, and it's time. And meals are provided and things of that nature. I believe they have breakfast and lunch. They did last year as well as part of the registration.
3 of us,
Yes.
we were all there last year.
Yeah. I was there on Friday. I missed the half day Thursday. I was out of town, but Friday was well attended. So I will send a reminder email. I hope everybody can make it. I'll let Commissioner Weston, who's out of town, know about it as well. And then we'll try to get you registered next week. But I'll be in touch very soon. So tonight I just wanted to have some open dialogue and a discussion with the commission on some basic training. We have a couple of you that are new. Connie Hunter's new, and Kate Roberts, you're both new. And Kristen's pretty new. Kristen started in July. So, and this is training. We should do some yearly training. Now a lot of cities are relying on the league or the institute, like the program they have on March 22nd, but it's okay for city staff to provide some basic training now and then as well. And so that's what I wanted to do this evening, and feel free to comment, and let's have an open dialogue and just discuss these topics. I tried to make it not too boring. I didn't want it to be 25, 30 pages of slides. I just kind of have some slides, and let's talk about those. I found a couple funnies. I couldn't find much more, but plugged them in there if you had a chance to look. So Planning Commission, a little bit about the Planning Commission. The Planning Commission is created and controlled by city ordinance, and the duties are City Code Chapter 1712. So if you haven't had a chance to review that, that's on our city website. You can go to City Code. Title 16 is our subdivision ordinance, and Title 17 is our land use ordinance. And it goes through some of the duties. It goes through all the duties of the Planning Commission. I did notice one thing. Commission members, and Logan, you might chuckle about this a little bit. As you know, we've done some updates to the subdivision ordinance recently. And as per state code or Senate Bill 174, those of you that have been here and we've gone through that process, I found a little wrinkle in 1712 where it still talks about you making a recommendation to the city council for preliminary plat approval of subdivision plat. So I've talked to Matt, so you'll see that's pretty soon. We're going to have to amend that section and add that duty to the Planning Commission, because since last year's legislative session, they put a new bill in place known as Senate Bill 174. It's a 2-step subdivision review that's being mandated throughout the state. So the subdivision, a preliminary subdivision plat, will come to the Planning Commission for review and approval. And then the final plat will be submitted to city staff at an administrative level, and we'll go through our TRC process with city staff and our city engineer reviewing it, and then allowing that plat to proceed and record. So no longer will subdivision plats be going to the city council. So before, you had to do the preliminary plat at Planning Commission. That was a recommendation on preliminary plat approval most of the time, or denial. Then it would go to the council, and the council would approve that preliminary plat. Then they would submit a final plat, and that would come back to the Planning Commission, and then the council. So they're taking a step out in an effort to streamline the process. I'm fine with that. Larger cities along the Wasatch Front have been doing that for some time, and I've worked at some cities that have had that process in play for a while because of the population. So subdivisions will now no longer be going to the city council as of February 1st, 2024, so less than a month away. So they'll just be coming to the Planning Commission. We try to make sure that they meet all requirements before we bring that preliminary plat to you. So a lot of times it could be through the development process for 3 or 4 months and multiple TRCs before it gets to the Planning Commission, just depending on the application, the developer, the engineer, how complete it is. A lot of times they have to come a couple times to get that plat just right. 2 staff at our weekly technical review committee meetings where staff reviews before we bring it to you, the Planning Commission. So that is one. And then state code, the powers and duties are defined in city code and Utah code, and that's section 109A 302. And that, I didn't include that. I mean, you can go to the state website, utah.gov, and just put in state code, and 10.9, you can review that. It's basically 2 pages. It talks about training and powers and duties, and our ordinance matches that pretty much. It's just that we have to slide the subdivision approval from city council duty to planning commission duty. So in our effort to clean up Title 16 and Title 17, we didn't look at 1712, which is PC. So basically, it's just a sentence that has to be put in a different section of code.
Can I add, there's also a lot of just, the whole section of code talks about the whole purpose of all of this process of Planning Commission, City Council, what the whole purpose of Land Use and Development Act is, and the powers granted to the state. So it's actually really beneficial to read through it and kind of understand what's there, what's
Sure.
written.
Thank you. And then apply the development code and law and recommended policy decisions. So that comes from legal, you know, applying the development code using good reason and law. And if we get into an issue that is quite technical and we need legal counsel here, we have legal counsel here to join us in those discussions as needed. We're just a smaller city, and our legal counsel, we don't have an in-house city attorney, so we use legal counsel as needed or necessary. Because we're a little bit smaller. Next slide. So this is kind of our main topic of discussion this evening, so everybody understands administrative versus legislative decisions. So an administrative decision, the application seeks to develop under existing regulations. So if someone has a piece of property that is zoned R110, and they come in doing a subdivision of 1/4 acre lots or 10,000 square foot lots with the required roadways, the utilities, the lots meet the lot frontage and size, you know, size and development standards, regulations of the code. That's an administrative decision. Us bringing you a subdivision plat. That's an administrative decision and a review done by the Planning Commission. And now, with Senate Bill 174 taking place, that's the Planning Commission's review only, that subdivision review. And the reason I'm bringing up a subdivision review is we have one that will come to you in 2 weeks on the 25th. And so I don't want to talk about that item because it's not on our agenda, but you will have a chance to review a subdivision in 2 weeks at our next meeting. But that would be an administrative decision, or a site plan review. Like when we did the site plan for the updates to Dutchman's. We did a site plan last year for the dialysis center between Lammy's and the existing building there that were uses that, I won't talk about them, but the existing building that's there on the other side that could use a little work. But that was a site plan review. We went through that site plan review. That's a Planning Commission review. Administrative conditional use, that is an administrative review done by the Planning Commission. If we had a variance or something like that, that would be brought to the Planning Commission for an administrative review. But those are the items that we bring to you. Now, a legislative decision, that's the application that seeks to change existing regulations. So we've seen quite a few of those the last couple of years. You know, Silverado was a big one early in the year or the year before. I can't remember, it's all blending in, but you recall we had a lot of folks in the audience because Silverado wanted to go instead, and this is property directly east of the Harmon Center up off of Pioneer Parkway. That's currently zoned PDR, which allows for residential, but they want to change that zone to PDC because they're looking at doing retail, commercial out front, some apartments in the middle, and then the man caves to the north. Now that proceeded to the city council, but the city council did not approve the rezoning of the property on 2 of the 3 lots. What they elected to do was allow the application to proceed on the most northern lot, the rezoning at least, for just the man caves at this point in time, and then developers looking at what they're going to do on the project and may come back with more commercial, you know, for those 2 pads, just all commercial, or they could do townhomes as well. I think the council tried to encourage more commercial because it's one of our last areas that could be really nice for retail uses and commercial, but I think they're still trying to decide, and we'll see what we get on that. Another one, we had 2 this last year. One was a bit controversial. Neil Walter was looking to rezone the property on the corner of Gates and Santa Clara Drive. He's now moved away from that, and we just recently rezoned, had a public hearing to rezone that to RA for the larger lots, and then that went to city council and was approved. So that is a legislative decision where you're making a recommendation to the elected officials or council, and then they make the legislative decision. You know, they determine yes or no ultimately on that. Any questions on that? Okay. Administrative review. So the applicant is entitled to approval if, this microphone's here. All right. They have submitted a complete application, and the application conforms to the city's requirements and codes and state law, and they have paid all required fees. So this is something that we deal with on a staff level. They submit an application. Sometimes the application's complete, sometimes it's not. So we had a TRC meeting today, a newer application, and they've submitted a lot of material, but we don't think that application's complete. So we've asked them to look at some changes, you know, to their plan, and they'll probably come back to TRC in a week or 2. And then we'll determine at a TRC level if it's ready to move forward to Planning Commission. Sure, they have paid their fees, and we're working with them to meet item number 2, that the application conforms to the city's requirements and codes. They believe they've submitted a complete application. If you just look at the application and they've checked the boxes and they've paid the fee, but there's a little gray area sometimes. Some of the requirements, they feel they may meet the requirement, but then we sit down and talk with them and decide if it technically does meet that requirement through our TRC. Yes, Kristen.
When is TRC, and is that something that would be beneficial for me just to understand the process?
We have TRC on Thursday mornings at 8:30 a.m. I don't think that would be a problem. We've had people come and just listen. Like we've had some neighbors come because they knew the property owner was doing something and they just wanted to hear what was going on. We generally don't have PC or council members there, but I can ask and see if that's okay and get back with you, Kristen.
I mean, would it be educational? Like,
It could be. It could be. Basically, and Logan probably understands it, and Kate may as well. Maybe you've been on the other side of TRC. I know, Logan, you do civil engineering and land use, and you probably attend a development review committee or whatever they call it over in Hurricane or Washington. Generally, the developer comes in, we have their plans. It's kind of cool. It's slick. It's electronic now, right? We have everything on the screen, and we talk about the project and if it meets the code or not, what the process will be, if we can move forward, or if you need to redesign and come back. And so I'm not sure how beneficial it would be to you, Kristen. I mean, it may not. I've never had a planning commissioner ask that question.
Is it the first time you see a plan?
Yeah.
It is the first time?
Yes. Well, actually, they'll
Do you know what
submit
TRC stands for? Did you
technical review committee, yeah. I'm sorry, where I came from before was development review committee. Every city
Every
has
city
their
names
own name for that meeting. Yes.
PR, like they call it planning staff review and
The JUC is over at St. George, correct?
Well, it's
Yes.
it's actually planning staff review probably.
Yeah, that's the utility
Yeah.
committee, JEC.
Yeah, but I think you guys
Okay.
combined those 2 together.
We have, and we meet weekly. Like today, we had a few items and we met for about 90
would-
minutes. Some weeks are longer meetings, some are
It is
shorter.
the first time you see a project that's
Well,
from
yes.
the city.
Yes and no, because what happens is sometimes they'll submit a concept and just say, hey, Jim, here's my thoughts, what do you think? Okay, I think that's okay. And if I have any questions, sometimes the concept could be shared with directors, the city manager, city attorney, mayor, and others. But that's before they ever submit an application.
This is the official version.
Correct. Before everybody gets eyes on it and reviews it. Usually it's submitted ahead of time, you know, earlier that week or the week before, well before the meeting. And we're asking our city staff to look at it, to come with their questions at the meeting, you know, so we can move forward through the applications themselves. But
I would think that everything that's kind of brought up in TRC, you're gonna hear anyway.
You are.
Eventually, so.
that's with my conditions of approval and my issues that I bring up through the staff report. A lot of those things are vetted through TRC.
Is it a legal question as to whether I should come or not?
No.
No, I think you can attend, but I just want to talk to a few people, my bosses, to see if they're okay with that. Like I said, Kristen, no one's asked that question before,
Yeah,
so.
it's not typical for
Yeah.
commissioners to be there.
So,
So, this makes me think that you present it and you tell us that it checks all these boxes.
mhm.
But number two,
We're also responsible for verifying that as well, though.
Correct, correct.
number two is where sometimes it's not that I disagree with you, but
Right.
it's that I have a different stance on something.
Correct, and that happens. That happens from time to time. What we do is we do our best, you know, to go through the process and see if it meets city code. Sometimes it doesn't, and the applicants are persistent. And you know, this last year, we recommended a couple denials on rezonings because we felt it didn't meet the spirit of the general plan, or it didn't meet the general plan. And we felt that it could create a, you know, a land use issue between you know, two land uses so close together, maybe a health, safety, welfare issue. But we had a couple denials that came to you this last year. And so at some point, we have to allow for due process. Most of the time, those are legislative matters because they're trying to rezone a property or do a general plan amendment. And at a certain point in time, legal counsel will advise us that we have to allow them their due process and queue up the public hearing and move forward, even if we're recommending denial. Once we've determined they're not going to make changes, and so we will bring it to you with a recommendation of denial. But there are things that you may find from time to time that I may have missed. That's not what I try to do. We all do our best, but it happens on occasion, so.
I would say you
Yeah.
don't miss it, I just
Yeah,
may
yeah.
read it different or
Yeah.
something.
Yeah, interpretation. We can agree to disagree. That's correct. So that's our process. Kristen, let me just, if you'd like to come to one or two of those just to get a feel, I think we're good, but let me talk to a couple people that are my bosses just to make sure they're okay with it before I say yes. Are you okay with that? I'll get back in touch with you next week on that, so. So administrative review exceptions. So we have two. There is compelling countervailing public interest. So what we just talked about, public health, safety, and welfare issues which require denial, or the city has initiated proceedings to amend its ordinances that would prohibit approval of the application as submitted. So we've had two this past year where we felt that, you know, there was a countervailing public interest or a public health, safety, welfare issue where we recommended denial. Now, there are times that we could recommend an approval and the planning commission could disagree, and you could say, we disagree, we believe that we have health, safety, and welfare issues here or something else, and you base your motion on that. So if we have one that we felt was controversial like that, we could help you through a motion, or legal counsel will be here to help through that motion. The second is the city has initiated proceedings to amend the ordinances that would prohibit approval of the application as submitted. Sorry. We're currently doing that. We have a moratorium in place for our historic district. Shelley Harris is on our historic district committee with a number of other city residents and city staff. She represents the planning commission, but we're going through that process, looking at our design guidelines, whether they're ultimately called historic district design guidelines or standards remains to be seen, but we're going through that process, and until May 6th, until that moratorium expires, we won't process applications which we've identified through the moratorium until after the period is up. So that's an example. That's pretty common. A lot of cities do that.
The
when
city
they-
actually has to initiate or pass the moratorium though for it to be
Yes.
considered initiated, right?
Right, right. Now, I have seen some issues where the city attorney gets involved on pending ordinance, and it's known in the community based on public hearings and this and that, that there is a pending ordinance underway. Most of the time, it's done by moratoria. I just call it moratorium, but that's the way they do it to get the word out. And we have 180 days, that's it. No more. And so if we don't get the new ordinance adopted or the new standards adopted by that time, then someone could submit and still be under the old ordinance. We'd have to approve something under the previous ordinance, even if we're still in the process of trying to get a new ordinance or guidelines adopted. We don't anticipate that. We're going to move forward and we look to adopt something, but it could be that we have to make some changes in that year after it's adopted because, you know, we've got a timeline. We're going to do our best, but there could be some adjustments after something's adopted, and that's within the ordinance. It's pretty common. We do our best to address the issues that we think may come up, and if you get 8 or 9 out of 10, you've done good. A year or two later, you might find out you missed something. Like we missed that subdivisions are now planning commission, not city council, even though we thought we cleaned it up. So, voting no. If the decision is no based on one of the exceptions, you make findings of fact and conclusions of law on the record. City staff and legal counsel will help you through that or bring that to you. Substantial evidence is required in the record to support the decision. So we had 2 recommendations for denial last year, and those reports, my reports, were thoroughly reviewed by Matt Entz, city legal counsel. We had the findings and the conditions and, you know, findings of fact and conclusions of law. In Matt's opinion, we have the findings of fact, and it covers our you know, our basis, and he's our city legal counsel. So we do have those on occasion. We're not afraid to say no if we have to say no. So you will see that from time to time, not a lot, but I anticipate every year we could have a few of those because, you know, our resource, water and land, our resources are shrinking, and a lot of time people want things, and sometimes they want projects at, you know, as we all know, that could be more dense than what the residents want or what the elected officials feel comfortable with. We're hearing, you know, the legislative session kicks off next week on Tuesday, and we're already seeing, you know, there's some rumors and about some things that could change. I don't know until I see it, but some of the bills are starting to be passed out before the session, and so there's going to be quite a few, just like last year. There was well over, I can't remember the number, over 500 is what I had heard. And we had a lot in the land use arena, and there'll be a lot of land use changes again this year because they keep fine tuning. Every year they come back. And building code type stuff and building department items as well. So land use and building are things that they look out pretty much every year. They come back with something. Yes, Kate?
Jim, let's just hypothetical,
Yeah.
to understand. So substantial evidence, let's say something is a public interest issue. I mean, I can see substantial evidence with public health or safety.
Mm-hmm.
It's easy to document.
Right.
How does the city document public interest? Let's say a bunch of people don't want something to happen.
Yeah.
How do we do
Well,
that?
and that is something we've had to deal with a lot the last year and a half or so with some of these rezonings and large public hearings. That's public clamor. And that is discussed in this book, which I don't have any extras, but they'll pass this out in March. They gave this out to our participants last year. And a lot of times we can't make decisions based on public clamor. We have to determine if it meets the code and it meets all the requirements. Then you can recommend approval, you can recommend denial, but then that item goes to the city council. They make the ultimate decision because it's a legislative decision. Now they can say no, but you know, the planning commission could say it meets, you know, we've dotted our I's and crossed our T's. We believe this is right and this is good. The ultimate decision maker is the council, the elected officials. They could deny it, even if the planning commission recommends approval. That happens from time to time everywhere, as cities have dealt with that. We don't have a lot of that, but it can happen. But it's interesting because people will show up and they feel like the squeaky wheel gets the grease. And the way I look at it is we have about 8,500 people. As of July 1st of this year, they're giving us credit for almost 8,600 people in Santa Clara City. And we'll get 50 or 60 people show up against something. But where are the folks that may be in favor of it? They're not coming out. It's usually the folks that don't want something that are coming out. And then maybe one or two in support of the developer will recognize that. But we have to get through that. And that's the public hearing. We allow them their 3 minutes to comment and tell us what they think. But at the end of the day, the Planning Commission's tasked with making the decision based on city code and ordinance, not public interest or popularity. So
It's my understanding that's one of the biggest differences between administrative and legislative
Yes,
decisions.
yes.
Legislative decisions have more deference to allow for public clamor to influence it, whereas administrative decisions don't.
Right, it's very code-based.
And
Yes.
that's what makes it a challenge for us, because we have the public hearings, not
Here.
not the city council, and so they're coming here to, that's where the public clamor usually happens. And sometimes, in fact, I'll use an example of a development. It's going to be a code change that I had initially said no on. I denied it, and it was tabled and sent back to the Planning Commission. I went to this training and learned that that's not my duty. I'm not a city council member. The decisions I was making was based on public clamor, and that's the city council. You know, they review what we find out in these public hearings, then they review it and they rule on that, what's best for the community. We rule on, is it a complete application? Is it legal? Is there substantial evidence?
It's a meeting conditions.
So it's-
yes,
But
yes,
it's hard because public clamor happens at this level.
it does.
And so it was a challenge for me in the beginning because I didn't really know, God, we're having this public hearing. They're trying to get us to, and in fact, a lot of times the public will come to us and say, hey, this is what you need to do. Well, this isn't our decision.
Yeah, we're just making sure. it meets
It's the
code.
city council. We're just making sure that.
Right.
Process.
And thank you for bringing that up, Commissioner Whitehead, and that's a great question, Cade. So we put this out in the last few months, what you see here and what was included in your packet about public meetings, a public participation guide. And at council meetings, it's on our website. We have this available so people understand the difference between a public hearing and a public meeting, and when they're allowed to make comments and when they're not allowed to make comments. So at a city, public hearings, according to state code, they occur here at the Planning Commission. The public hearing is at the Planning Commission, where we have to take the comment, listen, go through that process, and then a recommendation is made. That's all on the record through the minutes as well as Zoom, it's all recorded. And so the council has the ability to go and listen and watch those meetings or read through the minutes before they're asked to make a decision. So they know all of the proceedings, even though it's a public meeting at a council level. So the public hearing and all the input is here. The public meeting is at council. Commissioner Walton got to see some of that. Her first night when she was appointed, the night before her first night on Planning Commission, when you were appointed, we had some folks here that weren't real happy about the Pioneer Point project, I recall, on Pioneer Parkway and 400 East. And they wanted to make some comments, but that's not their opportunity to make comments at that meeting. I mean, they kind of came up and during public comment talked about that project in a roundabout way. So since that time, we've put this public meeting, public participation guide in place. A lot of cities are doing this for, to educate and help people understand. The council has a monthly work meeting. And at the beginning of that work meeting, people can come in and talk about their issues or items of concern. That's when they take public comment at that monthly work meeting. So if they want to come and comment about things going on in the city, that's their opportunity. So they do get that monthly opportunity. And then we have public hearings here. If we need them every 2 weeks at PC, we do them. It just depends on what items we have and what the applications are. Now, some cities are doing, at times, they've elected to do a public hearing at Planning Commission and a public hearing at City Council. But Not many, because most now are following state code, and state code says that the public hearing occurs at planning commission with a public meeting at the city council. And really, they have access to all of that comment, and we would just be having the same meeting 2 or 3 weeks later with the same comments and the same time. So, you know, we have Senate Bill 174, where our elected officials up on the Hill decided to remove the council step in the subdivision plat and just do planning commission and city staff. They've done the same with public hearings, because instead of a 3 or 4 month process, it might be a 6-month process because of the extra public hearings, the renoticing that's required, and all of that. I don't know, it could change. You know, it's always a moving target. You know, someone could bring up a bill this year that says if you do this, you have to have a second public hearing. Now, we had kind of something unique at our last meeting, our annexation policy plan. That's completely different in state code than anything else we've read through that process. We just did the first step last month on December 14th, where we just opened it up and Ivan City came. But now we have to have 2 public hearings because it's an annexation plan with an expansion area map, and that's what state code requires. So when that's ready to come back, and there's some meetings that are occurring, so I don't have a date for that yet. It will likely be February when I bring that one back to you. But we have to do a public hearing, and then after that public hearing, we have to renotice it for a public hearing with the council. Now, that's the only one in state code I've seen like that, but it's because it's an annexation plan where you're recommending, you have a map and you're showing where you could expand your municipal boundary in relation to other cities and other communities. So that requires an additional step. Otherwise, the public hearings occur here, not in 2 places. So, but we put this together. We've received some thank you. That's great. I understand now. And thank you for that. Some people still want to do their thing, right? But most people are understanding this and the process and reading the guide. So, and it's on our website, and we make it available to those that come to meetings as well.
So this kind of circles back, but we've had experiences where the Planning Commission has made a recommendation and the City Council, and it's gone both ways. We've
Yes.
recommended denial and they've approved,
Yes.
and we've recommended approval and they've denied.
Yes. And that's because they have the legislative authority to do so. And sometimes we can agree to disagree. Sometimes, you know, folks worked really hard on a certain project or a certain, you know, topic and felt that was right, the correct way to go, but then the elected officials decided it wasn't. And so that's why they're elected, and that's why they make those decisions. All we can do is do our best through the process. So, but that does happen. And it doesn't happen a lot here. I know it's happened in the past a few times, Shelley, as you've mentioned, but I know other communities where they have quite a bit of that. So we don't have a lot of that, but it comes up quite often. So,
It didn't happen very much. I mean,
right,
but it was a learning experience, I guess.
correct. So administrative review.
Hey, Jim, before we move
Yeah.
on,
Uh-huh.
we talked about substantial evidence, and I think that's something that sometimes we wonder what it is, especially when it deals with public clamor. And this book talks about substantial evidence means evidence that is beyond scintilla, and 2 is a reasonable mind would accept as adequate to support a conclusion. And the book goes on to say that public clamor is not substantial evidence.
Right.
It's a decision cannot be based primarily on citizen comments. And then it uses an example. A real estate appraiser could comment whether a given decision might affect the property value. We hear that all the time. Oh, if you put this, that's going to affect all of our property values. But if it's a general citizen using or saying that, what expertise does he have? You know,
Right.
that's his opinion. Whereas if you
Right.
have an appraiser coming in and say, well, we know that if you allow a church or you allow this business to come in right in this neighborhood, it would affect appraised value. That is substantial evidence, not just a normal anybody off that.
Right. And then we would consider substantial evidence, and we would look at it with legal as well.
And it goes
So-
on to say in this too, that we are only sure they have the right to talk about that and get it on record but we kind of have to strike that from our minds when we're making, if it is public clamor,
Right.
if it's not that substantial, and we have to put all of our decision
Right.
based on the appraiser, not the property owner.
And
that's
we
in
hear
it.
that, you know, they come and in their mind, it's going to do X, Y, and Z, but a lot of time that's just clamor. What is that based upon? And
Right.
so that's the hard part, you know, listening to that and really deciding as a commission and staff and others, what are the issues, what are the main issues here? You know,
And we hear
what
that a
makes
lot with
sense versus
traffic.
clamor? Yeah,
You know, every time
Yeah.
there's a subdivision goes in, the
yeah.
general populations, oh, the traffic now is gonna be out of control. Well, there's actually been
A study done.
companies that have been hired, and that's,
Right. It's hard. A lot of people want to preserve their place, and growth has occurred. And we know a lot of people have lived their whole life here or been raised here. They remember what it was truly like versus folks that have moved in the last 5 or 10 years. And a lot of those are the people we see at quite a few meetings saying, we don't want this. And they've only been here 5 years, and that's what happened when their subdivision developed, so they could move in. So there's going to be growth. We just have to try to make it the best we can. So,
So I have,
Oh,
I need
uh-huh.
one clarification. I know
Yeah.
I'm throwing a
oh,
wrench
you're
here.
fine.
Even on a legislative zone change,
Uh-huh,
we are still only the reviewing
correct.
body, administrative, check the boxes,
Correct.
that's it.
And you make your recommendation, that's it. That is correct.
now in our discussion, we can have a comment, we can still have our feelings and talk
Yeah.
amongst it.
Yeah,
But our decision is the application complete?
mm-hmm.
And do we recommend it to the city council, or do we deny, or send it with a denial? And then they'll take our comments too. If we, you know, I don't think this is good, but the application is complete, we
Okay,
recommend it.
Okay, so
They'll take
even
our
if it
comments.
is complete, I can say that, but I can also not think it's in the best interest of the city, and I can say
And,
that.
Sure.
and you always have the right to, if it's motioned to recommend, you can deny the motion. You know, that's why there's 4 or
Yeah.
5 of us here. There's a
Okay.
quorum, because it's so.
I'm
You
good,
can-
I'm
you-
good.
You can vote no, you can vote yes, yeah. Or you can make a motion, you know, and see if it's seconded.
We just
So-
try to not make our motions or our votes on public clamor at this level. That's done at the city
Right.
council.
Right, right. All right, the next item, a city is bound by the terms and standards of their adopted development code and shall comply with mandatory provisions of that code. Second, a city may not impose a requirement on an applicant that is not expressed in state law, city code, or adopted infrastructure regulations. 3, each city shall process and render a decision on each land use application with reasonable diligence. 3 comes up from time to time with an application that maybe an applicant is tabled, or, you know, the thought is it could be denied, but then they ask for the item to be tabled. Then they work with staff to redesign, and then they want to bring it back to the planning commission. We have to determine at a staff level when it's ready to come back, and we can't delay them for too long. Usually, once we get a submittal, we have a couple weeks to review it and determine if it's complete or not, and then we try to bring it back within 30 days or so. We cannot just indefinitely hold things up. And so that's where they get with the application, has to be moved forward with reasonable diligence. And then we're bound by the terms of our code, our development code. And that's a big item, because sometimes, you know, you'll hear, well, what about this and what about that? And we really want this and we'd really like that. We can't do that. We can only condition it or only require what's required by our development code at this level. If a developer determines that he or she wants to go above and beyond and do something more, that's up to them, but we can only require what's in our code. And generally, those are addressed, you know, the items are addressed in our staff report and then the conditions of approval. So those are the kind of requirements we can place on them. We can't place something above and beyond that's not in our code. And that's when cities get in trouble. When they do that and require that of an applicant. I've even seen cases where the developer says yes to get an approval, and then a month later, the attorney's calling and saying, we don't have to do that. You're making us do something that doesn't meet code. And then you have to get your attorney involved, and then you have to determine if it was legal or not. If it's not, it might have to be reconsidered by a planning commission. You know, that might have to be removed. So we try to avoid that, you know, where we can, if possible. Legislative decisions. So the planning commission is a recommending body, like we've been talking about. And we get into the policy questions, and the top three are, should the general plan change? So we've seen some general plan amendments this year. Neil Walters comes to mind, as well as the one over at Silverado. Should the zoning change? So sometimes people need a general plan amendment and a rezoning. And so we've determined at a city level to separate those processes. That's the direction we've been given by our legal counsel and the mayor. So we do a general plan process, and then if that goes right, then we allow them to submit for a rezoning, you know, after those proceedings are done through that process. So should the zoning change? And then second, should the development code be amended? So when we bring code amendments to you, like the rewrite of Chapter 16, which was our subdivision ordinance, and a lot of the things in Chapter 17 that we do, you'll see quite a few code amendments. We probably do 10 or 12 a year. We're trying to catch up and meet state requirements. We find things are brought to our attention, or we find things that may not meet state code. And development code amendments, let's say we're the busiest in the spring and summer because the elected officials just changed state code, and now we have a 6-month window to amend our code. You know, they usually give us a timeline. You have this much time to change your code to meet what it says in state code now. So it's been a lot of that the last 5 or 6 years. So you'll see some code amendments this spring coming forward based on what laws were passed up on the Hill. So. And so those are the big three right here. But all of these, again, policy questions, you recommend, you know, on these, and then they go to the city council for a final decision. Due process. I thought this was kind of fun. We've seen a lot of this. No. We even had, I don't know, if it might have been at city council where we had someone bring signs, and the mayor told them, you'll have to put those signs down. It's okay out.
No, it was two.
Was it here?
It was planning commission.
Oh, okay,
Yeah.
thank you.
It was a public hearing.
Yes.
It was a female that sat in the front row.
And Matt was here, that's
asked her.
correct, that's correct. And the way he reads it is, if you're outside talking to folks, or maybe you're in the foyer, but once you come in here and we're having the public meeting, you need to put those down. And so I found this, and it's just, that's what we get, no, you know, those are the people that are here, vote no, you know. The sky is falling, you know, kind of, I couldn't find a Chicken Little skit. Maybe some of you are old enough to remember the sky is falling, but we get some of that. So the applicant's rights to be notified of a pending action and to be heard prior to the decision. So the way state code reads and the way our ordinances read, well, not so much the ordinances, but state code, we have to give our staff report and recommendation to the applicant, I believe 48, it's either 48 hours or 72 hours before the meeting. We send it out the week before when you get your packet on the Thursday before, so we're in compliance. We don't want to be sending stuff out on Monday or Tuesday when there's a council meeting on Wednesday night or Thursday night. We want them to see that and have that a full week ahead of time, just like you guys get the packets. So. And then they have to be heard. You know, we give the applicant time to speak. Usually staff presents. The applicant has the option of coming up and saying, well, I had these 2 items I wanted to discuss that was missed by staff, or I agree with staff. It's really up to them. But they have the right to be heard and discuss their application with you. And then public rights. We've talked about this already. So administrative decisions and none. Legislative decisions, public hearings. So if someone comes in for an administrative decision because the R110 zone property across the street is the same as theirs, but they don't like how many lots they're asking for, they can come and listen, but if it meets the requirements, it does. And we go through the process of approving it. You know, we don't open it up. That's not a public hearing. They can meet with the developer, you know, and see if they could get that individual to remove a lot or something like that, but we can't do that. You know, we have to, the due process is to go through the process, And when the right, it's the legislative decision with the public hearings. And some items have multiple public hearings, as some of our commissioners know. We'll do a public hearing and then the plan changes 6 months down the line and then we have to come back for another public hearing. Or we do a public hearing and they approve it and entitle it, but they let the usually entitlement's good for a couple years. They don't proceed. Then they come back a few years later and they have to have another public hearing. Or they change the project. They decide to change the project, and so that's a different public hearing. So due process is important, and I think we get into that public clamor a little bit. We've heard comments such as, I'm the neighborhood spokesperson and I need more time. We typically don't allow that because sometimes there's 5 or 6 people that are self-appointed neighborhood spokespersons, but they'll stand up and say, you've heard the people. None of us want this. You need to vote no, right? Again, that's public clamor, based on who came in, and just because they showed up in numbers, they want you to vote no. So, can't make decisions that way. But sometimes people think it's a vote or a popularity contest, If we have 50 people that are willing to vote no tonight, then you need to vote no. And they don't understand the process. And so sometimes we have to educate them. We have the participation guide. Sometimes we'll go out in the hallway and talk to folks and try to help them understand. And then I had this one, all discussions and decisions decisions on pending applications must be done in an open and public meeting. So this is kind of funny. So we have to talk about the items on the agenda that evening, where cities get in trouble, and there are cases where this has happened. So-and-so wants a conditional use for a gravel pit, but it's not on the agenda. Can we just add it to the end of tonight's agenda and talk about it? How does everybody feel about that? You cannot do that. That's when you get yourself in trouble. But it happens sometimes where people want to talk about items that aren't on the agenda. We can't do that. That's not allowed. This is kind of funny. All those in favor of what we discussed in our email thread at Larry's son's birthday party, say aye. So.
Well, and this is something too that we see all the time, because we'll get emails from our
Yes.
neighbors, our friends,
Yes.
and is what I've done with those in the past is I just forward them to everybody and forward
Yep.
them to you,
Yep.
and I respond, thank you, but you don't want to engage in conversation because we can.
You do
That's an
not.
ex parte.
It
or
is,
however
and
you
I'm
say
going to
it,
hit that
violation.
next. That's an ex parte number 2 here, ex parte communication. So elected officials can do that. They're voted, they're elected, they can have those communications. Planning commissioners cannot. If they email something to you, you can just say, thank you, I'll pass this on to city staff or the city attorney, but you cannot, you cannot discuss their application with them prior to our public meeting or public hearing or here at the Planning Commission. And that's where due process, those are the pitfalls. Personal investigations, really getting into something or into areas that you shouldn't. The ex parte contacts, conflicts of interest, that does happen on occasion, where a planning commissioner may be working on a project and their professional, what they do. Maybe the client's here for a subdivision plat, but they drew that subdivision plat for the client. They have to make that known to the rest of the group. I don't think that's a big issue. That's something where you could still participate, but it's case by case. If there's money involved and you're part of the deal and, part of that investment or project, you can't be on the dais and vote on those items. You have to remove yourself from that. And something like that, we'd need to know ahead of time, and myself and the city attorney would talk about that, to make sure that's addressed prior to the meeting. If you can sit on the dais and participate, or if you need to just be in the hall for that item. And then once that item's decided upon, you can come back in. This happens on occasion. I've seen it. Had a developer and a realtor in Sandy City, and in the 10 plus years I was there, there were a couple occasions where they had to remove themselves because they were involved in a certain item on the agenda. But that's the way we handled it. We just had them go out in the foyer, wait till the item was over, and then brought them back in. And then they, participated in the meeting. Yeah.
To ask this question, would it be considered a conflict of interest if you personally had your sights on purchasing a lot in a development that was on the docket, going to monitor, you're not going to get money from the developer necessarily, but you have an interest in like want it to go forward because you want one of those things. But I think that's not necessarily falls underneath that, but
Yeah.
it's not a good look for sure.
Yeah, I'm not sure. I mean, something like that would come up, I'd have to talk to legal counsel. Now, the mayor, his name is on Rosenberg Engineering, and we know Mayor Rosenberg is, you know, partially retired, but works a little bit, but he's sold a lot of the interest to other principals there now, but he doesn't vote, you know, he conducts the meeting. But he'll, at the beginning of the meeting, say, I want everybody to know that my company has done the subdivision plat here or worked on this, so I'm letting you know on this particular item. So if that were to be the case with the planning commissioner, just let me know ahead of time so I can talk to legal counsel and we can make a decision. You know, if you feel you have a conflict, so.
I've not voted on items that I'm going to be
Lending on or.
lending on,
Yeah, and I think that's perfect. I think you did the right thing there.
but I didn't notify prior. I just said I'm not voting.
Yeah, yeah. If you can't, you can't, but it's always helpful, you know, to know if you feel like you do have a conflict, if you could let me know and I could just talk to the city attorney and we can determine if you do or not. Again, I don't have access to have him here every meeting, just on an as-needed basis because we have to pay. You know, they're not a full-time city
And
employee.
those would be good to bring up at the beginning
Yeah.
of the meeting. Say,
Yes.
I have a conflict on this item on the agenda, and say what it is or whatever.
Yeah.
Can I ask a question?
Yes.
Curtis, you said even email someone from a citizen. We cannot talk to citizens? I thought it was just if the builder.
You know, it's a
or the
gray
developer-
area. I think you can, but
So that's more
talking to
the
a
city
citizen is
council.
one thing.
The
Yeah.
city council are elected, and if it's something that's a legislative decision, it goes to the city council, and they're the ones that do what's best for the city and the community. I know it's,
So the way I understand,
I think we also have the interests of the city community in our
yes,
decision-making.
yes.
but
So-
I know having outside conversation
Right, so-
about something, that's where it gets really, really
The
sketchy.
key is here, the key, the way I understand it is, you know, it's a developer or someone involved in the project that's trying to get an approval. Or you have residents that are trying to sway your opinion to vote no on something because they do not like it. I think you have to proceed with caution. You have to say, I hear you, but this is a decision I need to make with my other planning commissioners. I'm not going to engage with you on this right now and have a big debate. This is a decision for the planning commission. If someone just wants to say, hey, you're on the planning commission, I heard that this subdivision's coming down the pipe, do you know when? I don't think that's a big deal if it's something that's been reviewed, but if it's a public hearing, if it's something that's going to be controversial, if it's something where, you know, they're going to bring a petition in and petition the city to deny it, or they're going to appeal a decision, I think we need to be careful. I would tell you to proceed with caution. If you have questions, we can ask the city attorney. Kristen, I know your husband's a judge and he knows the law. Maybe you could ask him some of those questions. I don't know that I can answer all your questions this evening, but what I've always done in my 20-plus years and with other cities I've worked on, and that's what we've told planning commissioners, just, you know, do your best, proceed with caution. Don't get into a lot of dialogue or debate with folks. Just let them know, I hear you, I understand what you're saying, but it's a planning commission decision, you know. Thank you for your input, or thank you for, you know, your comments about the city.
Nothing would be
Yeah.
worse than having a conversation with, we thought, someone that was a friend, and then they show up at public hearing saying, well, Curtis, you said this to me the other day when we were discussing this item. That's when it's just like, it looks bad for everybody. So you'd never want to really give a big
It's tough.
opinion on the outside.
Yes.
Listen to
Yes.
them. There's another paragraph
Go
that
ahead.
kind of talks about that.
If you want it, could you read it for us, Curtis?
Yeah, it says, one common problem with the right to confront the evidence arises when individual members of a land use authority, such as the planning commission or city council, have conversations with individuals involved in an administrative application which are held outside of the public meetings and outside the presence of other individuals with a stake in the outcome. For example, when a subdivision is proposed, a chat between the subdivider and a planning commission member outside the public meeting would be ex parte. It would also be an ex parte communication for that planning commission member to chat with members of the public, a member of the city council, or others about a pending administrative application.
That's administrative.
So this talks about administrative, legislative, a
That's
little
one thing-
different, but it's,
that's-
A subdivision
one thing I
plat, a
noticed-
site plan, yeah.
That's one thing I
Yeah.
noticed with that book. You gotta definitely distinguish between when that book is talking about administrative and legislative, because they're quite a bit different. And so when you're reading some of those paragraphs in there,
and most of them talk more about administrative with
What
us.
page is that?
there's less
It's in
deference.
chapter 18, it's page 234. And it goes on for about 3 pages, kind of dummying that down a little bit, so that may be a good read for you.
I think it's just a common sense approach and proceed with caution.
careful.
You'll be careful, is all I can say. Because I've seen that too, well, I talked to so-and-so and he said, he or she thought that this would be just fine. So why is it not fine now? We just have to be careful, is all.
But the citizen
So.
can talk to the city council.
Correct. Yep.
That'll be my answer.
But I
Yes.
think it's a good opportunity to educate, because they still think we are the ones that say yay or nay on a lot of these decisions. We're the planning commission, so what we do is we hear you, we collect all the evidence, pass it on to the city council. They're the ones that make the decision.
Yeah.
Go hit them up. Then you can kind of take some of the heat off of us, as much as I hate to be the
Collect
Yeah.
fish
evidence means listening to them.
on record.
Okay. So tell them to come to the meeting.
I think it's okay to listen and say, again, thank you for your comments. Come to planning commission next Thursday night. So, well, what you should know, and this is the last thing I had, know the development code and general plan, which you have copies of. Know the municipal land use act, so that's the title 10-9A, and it says 101, but that's just 9A, which is the land use, the land use provisions in state code. Remember that you represent the city and must give due process in all things, and findings and conclusions are good. That's why a lot of our reports, especially if it's a legislative decision, we come with findings. So we have the report, we have the conditions of approval, and then we have findings. Findings that are required, and the city attorney helps me with those as needed or necessary, and the legal counsel, the elected officials, and others feel that if we have the findings to support the conditions of approval and the recommendations that are made, then we're covered if we get into litigation or have an appeal. So that's, if you don't have those things and there's an appeal, that's where you get in trouble. And that can take months and months and sometimes years. So that's what I had for you tonight on this. I think it's been a productive, good discussion. And I'm excited about the March 22nd, and I'll get right on that for our training. And the city, we will pay for that training and get you all registered. So I'll reach out to you early next week on that. So that's all I have at this point, Chair.
This public meetings guide, is that on the website?
It is.
You hand it out when they come in?
Well, I know, yeah, I
See, that's on
know,
the city website, I saw it the other day.
it's on the city website, and a lot of times it's on the back bench when people come in too, especially when we know we've got a lot of people coming for a controversial item, because we generally know ahead of time, because we're getting emails and calls and being told, and then this whole chamber's full. So we kind of know that ahead of time, so.
Okay.
I think that's a good idea.
Can I
Yeah.
ask you a question?
Yeah.
Since I'm new, and I'm so new to this, so when we have a meeting and everybody comes and they have the public hearing,
Mhm.
we make our decisions at the end of that meeting, right here?
At the end of that item.
At the end of that item?
Mm-hmm,
Okay.
Yeah.
So do we just sit here and discuss like this and
mm-hmm,
say yay or nay?
correct,
With all of them watching?
correct,
Okay.
Good times.
No pressure.
yeah.
You can table things, right? If there's
We can.
some evidence
Yeah.
that you just need to figure out before.
There are times when we table or continue an item because it's felt that we need more information. And so that could come back in the next 2 weeks. Generally, it's within 30 days when something comes back, because they have to do some work on their side, to get it back to staff and have us look at it and then do a report and bring it back, put it on an agenda. It happens on occasion. That can happen a few times a year as well. So, but yes, usually the items introduced by the Planning Commission chair, staff gives the staff report or presentation like I did at that December meeting on the annexation plan. And then the chair lets the applicant speak to the item. And then if it's a public hearing, then the chair will open up the public hearing to take comment. We give each individual 3 minutes. We have a timer. So if they go over, it lets them know it's time to sit down and let the next person up. And then after that, the chair will kind of turn it over to the Planning Commission for discussion, and then you'll make a motion. Most of the time. And sometimes that conversation takes a while if it's a complicated item. So,
Right.
yeah.
Okay. So on average, how long are these meetings? Depending on,
Well, tonight is
Pretty
a
good.
shorter
They can
meeting.
get pretty good.
I think
Yeah,
the
this
latest
one-
I've been here is 9:30.
Yeah.
And that was on a couple tough
Yeah.
public hearings.
Every once in a while, we might have a 9:30 to 10 o'clock meeting. That's the latest, but most of the time, we're done within 90 to 120 minutes, sometimes less,
okay.
Prior to Jim's been a huge asset to bring on the city. Prior to Jim, they would get out of control. We didn't really have control of the meetings, and they would go super long, and it was a lot of the same rhetoric being
Yeah.
regurgitated, but it's
Yeah.
an effective
We'll
meeting
try to
now.
keep them under
Yep.
control.
And that's why we moved to 2 meetings a month. It used to be 1 meeting a month, so everybody needed to be on the agenda. Maybe some items weren't quite ready. And so we try to keep the meetings, if we start at 5:30, if we're done at 7, that's great.
One
Just
thing that's-
7 or 7:30, yeah.
That's good these days too, is that more of the information is given out to the public. A few years ago, like, the public couldn't get it. Like, I remember when the Santa Clara Inn came through the first time, it was a chore for me to come down and get some information on that. And that's been changed, and it's good. That's a good thing.
Mhm.
So I think that helps with some of the people's knowledge of knowing what's happening, as opposed to just more, if it's more unknown, there's more fear that can be
Yeah.
brought to people or
Yeah.
whatever.
And is that in email form, or is it just listed on the website?
It's on the website.
So
That's
people
what-
can just
they
go
even
to
put in
it.
those QR codes that link to it, and
Right, okay.
Yep. That's all I had this evening, Chair.
no, that's good. Yeah, we'll look for that more training. And one thing too to note, that if you go to the utahlanduse.org website, you can actually get the recordings from like all the past year conferences and watch them if you think that would be beneficial to you. And they have access to that book that Curtis has been reading out of on there. So,
I will make sure that those of you that don't have a book, get a book if you come on the 22nd. I'll get them for you.
yeah.
I want everybody to have a
So
book.
yeah,
So
we got one of those, and
they were passing them out last year, so they should have them again. So,
Lena gave me one of these. Or Lena
yeah, she may have had some extras, but I don't. I just have the one, and we'll get some more. So, soon.
okay. So I guess we can move on from item 4A to item 4B, election of a plan commission chair and vice chair for this year 2024. So I think we turn it over to plan commission for nominations for those two positions and discussions.
I'll nominate Logan to stay on as chair and Curtis as vice chair.
I agree.
You guys,
That was easy.
I mean, you
Me too.
served, but it was a short,
Short stint.
yeah, so I'm all in favor of,
If they're willing to
Continuing
serve and the others
Yeah,
agree.
I'll keep doing it.
To second it?
Yeah, we would need
We'll
a-
make a motion and
Make a
vote
motion.
on it, but I just want to make sure there's no anybody else that wants to be nominated or wants
Yeah.
any other nominations.
Good luck.
Okay, so I guess let's.
I usually argue, but I think it's probably the best. You did a good job the little bit you came in replacing Mark, and I'm happy to be here, support anyways.
I was vice chair first, then I got.
for about 5 minutes,
About
Logan.
5 minutes. So, yeah, so I guess we got a nomination. We look for a
I'll make a motion that we appoint, nominate, elect Logan Blake as the chairman of the Planning Commission and Curtis Whitehead as the vice chair for 2024.
I'll second.
Okay, I got a motion by Commissioner Walton and a second by Commissioner Harris. All those in favor of this motion?
Aye.
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 That's like a unanimous motion, so that'll be the results, and we'll move on to that. I guess is there anything additional in 5A? It says none.
No.
No discussion items. Item 6A, that we need to approve the minutes from our December 14th, 2023 meeting.
I'll move.
The only thing I saw is, I know I had said, and I don't remember where it was at in here, I should have put it down, but I think they credited one of you guys, not that any of us need credit, but just in case you guys were fine getting the credit for it. I said it, and I think they maybe said you said it, Logan.
I noticed that quite a bit, but I think
There was
that-
a spot. I couldn't remember if I said it or not.
So it was under the E EMS.
What page are you on?
I don't think that,
Oh.
I think that was a commissioner.
Page
but I'm not
5.
sure it was me. Asked about who's gonna police the reservoir. I know that was asked.
Yeah,
but think
I
was-
believe it was me that had mentioned that I'd asked that, and, who's
I
going to
believe so
EMS
too.
and-
Who does it say on there?
it says
Commissioner
Chair
Blake.
It
Chair
start,
Blake.
the paragraph starts,
Okay.
Chair Blake asked which entity, and I believe that was me, but I don't, it doesn't need to be changed as long as Chair Blake is comfortable with that being on record for him.
I think
we can change
I think
it,
we just put it
yeah.
in the motion that we needed to change, what page is that on?
5.
Page 5.
We can change that. We'll just put you down, Curtis, instead
That's
of
fine.
Logan.
That's the only thing I saw, other than that, it looks
Okay.
great.
Did you see something like that, Sherry? Did you have
I
one?
don't, from time to time, I will have said something and it isn't, but I don't, if the essence is there, I don't
Okay.
care.
Okay. Thank you.
I will move to approve the minutes as presented with that update, noting that Curtis made the comment about who polices the EMS around the reservoir.
For the reservoir.
I'll second that.
Great. Got a motion by Commissioner Harris, second by Commissioner Whitehead. All those in favor?
Aye.
Aye. Okay, those minutes are approved unanimously.
Just one thing, see you in
With
2
that, we
weeks
need
on the
to
25th.
Talk about
Yeah.
our next meeting will be in 2 weeks.
On the 25th, that's
25th
it.
of
And look for an
January.
email, we'll be out Monday, but look for my email Tuesday about this conference on the 22nd, and we'll try to get you registered by the end of the next week, get you all on board, okay? And I'll reach out to you Tuesday or Wednesday, Commissioner Walton, about your question about TRC.
I will be out of town for the next.
Okay,
If you email me, I might get it.
all right. Well, it gives me time to ask, and I'll respond to you, so I may wait till after registration. So are you good with the March 20?
26th or 22nd?
22nd.
22nd.
So 21st and 22nd?
No.
Just the 22nd, just the Friday.
Just one day off Friday,
22nd.
yeah.
You also have the option of just watching it online if you can't be here physically, I guess.
I will email you
Okay,
about that before I.
all right, I'll
Yeah,
send
'cause
my
we,
email
as
out.
plan commissioners, the state code to get, was it 3 hours a year?
It
professional
is,
development?
it is, and so that, you get your certificate for attending that for the year.
But last year you were saying it was 2 days. This year.
They split it into 2 days. I don't know how well attended it was the first day, so it looks like it's just all into one day. So, or they've decided one day will suffice, so,
And this will count, and
for your
'Cause I
annual
get-
training, yeah.
I get the emails all the time, and I don't know what
Oh, okay.
constitutes the training that qualifies for.
It's this training, so
Okay.
we get, you credit for 1 hour today, just the 101 training, the basics that staff gives you, and then the additional 3 hours you get credit for if you attend this.
You could go to the League of Cities and
Yeah.
Towns too, if you so chose, but that's always in Salt Lake.
Okay,
Unless I let you know.
okay. Yeah, I mean, there's other ways to do it, but they're coming to us now. It used to be you had to go up north or just did it virtually, but now they've made a commitment to come down every year to give us updates, which is good.
Because I used to
because-
do the online stuff, but I didn't
Right.
know if it
Yeah.
counted.
That I don't know. I do know, though, that they were given, the certificates for everybody last year that attended, and that gave you your
I
credits.
did get that, yeah.
I do, I have it. Thank you.
I think you can watch it online later and still.
You can.
You can.
Yeah.
You can.
I think you can. It's just if you can come.
Yeah,
I think
It's
you'll
better to
enjoy
come
it
'cause
because
then
you can ask questions
You can ask
too.
questions and get some
Yeah.
answers.
would love that if I was there asking.
You would.
Oh. We'll put you up front.
Well, it's interesting
I
because you
remember- I
have
remember Steve Kemp
realtors,
asking
you
lots
have
of questions.
attorneys, you have
Yeah.
city managers, it's everybody. It's not just commissioners, planning commissioners. And so you get a lot of different viewpoints and real world, well, this is happening in our city. And we're like, oh, that happens in ours too. I didn't even think of that. So you get a lot of answers that are unimplied.
And a lot of them are connected to the league who are up on the hill during the session, so they can give you that firsthand approach. So, thank you.
Okay. guess
I
with that-
will move to adjourn the meeting until the 25th of January.
Second, got a motion second. All those in favor, say aye.
Aye.
Aye. Okay, adjourned.
Thanks, everyone.
Okay, remind me again how it goes on. Oh, just X up here, okay.
Do you want these turned off?
X out of there.